Hello, everybody.
Hello.
There you go. My name is Mitch Weisbrot, and I do a full range of financial services, from life insurance to investing in mutual funds. But the area that I concentrate most on is estate planning for families who have children with special needs. Just so you know a little bit about me, I am married with 4 children, all boys. I cannot make a girl, no matter how hard I try. And on Valentine's Day, 1998, my wife gave birth to 2 absolutely gorgeous little twin boys. I try to tell her what a wonderful husband I am. After all, most guys on Valentine's Day, by the way, for candy. I said, I gave you twins. What could be a better gift than that? And of course, she wasn't very impressed and thought the best gift she got that day was the epidural. But anyway, when the boys were about 7, 8 months old, I noticed that they weren't doing some of the things I thought they should be doing, and I had concerns. My wife said, they're boys, they're a little slow, they're twins, they're a little slower, don't worry about it. But I was concerned. And eventually we got involved in early intervention and programs like that. And finally, we took them to the head pediatric neurologist at Schneider's Children's Hospital, who told us, well, of course, you know they're both autistic, right? And your world ends at that moment. I mean, how is that possible? These sweet, beautiful little boys are both autistic. And you go through, quite frankly, a little bit of a mourning period, and eventually you snap out of it and you have a choice to make. Either you could stick your head in the sand and assume it's all going to go away, or you can be proactive and do whatever you can to make sure that these kids' lives are as good as they could possibly be in every single way. Scholastically, economically, socially, medically, and what Andy and I are going to talk about today is the financial end of things, the economic end of things. Because the way I look at it, as long as I'm alive, I can take care of my boys. As long as my wife is alive, she can take care of the boys. My greatest concern and biggest fear is, well, what's going to happen after we're both gone? What's going to happen then? Children with disabilities are entitled to certain benefits from the government, both financially and medically. However, if any money is left in their name, they're not going to get the aid that they're entitled to. So that means if your child has money in a savings account, or mutual funds, or savings bonds, and it's more than just $2,000, all the aid that they're entitled to, they're not getting. So as their parent, as their advocate, you need to make sure that all money is removed from your child's name. You need to remove it now and in the future, which means adjusting your will properly so money isn't trickled down to them down the road. Most people have a simple I love you will, which means if anything happens to me, the money goes to my wife. If anything happens to my wife, the money is equally distributed amongst our children. Well, our wills are a lot more complicated than that. And you really need to sit down with an attorney whose area of expertise is dealing with special needs planning. We're fortunate to have Andy Cohen here today. He is that type of an attorney, and he'll be speaking in a little bit. But besides the will, there are other areas of finance you should be thinking about to make sure that money doesn't end up in your children's hands. For example, you have a life insurance policy. If you do, who are the beneficiaries? Who's the primary beneficiary? Who are the contingent beneficiaries? Chances are you probably have your spouse as the primary beneficiary, but chances are also that you have all the kids listed as the contingent beneficiaries. And I always like to look at the worst case scenario. If anything were to happen to the 2 of you, and that money is filtered down to that special needs child, the results would be devastating, as you've now just disqualified them from government benefits. Something else to think about. Do you have a retirement account? Do you have a 401k or a 403b or a personal IRA? Same question. Who are the beneficiaries? Who's the primary beneficiary? Who are the contingent beneficiaries? Chances are, when you started your job, just check off the box that the kids are the contingent beneficiaries. Well, you know now that that needs to be adjusted. That needs to be changed. You need to ask the tough questions. Speak to your parents, speak to your in-laws, and ask them, were you planning on doing something for our child? If you were, we really appreciate it, it's very generous, but you can't. And here are the reasons why there are other things that they can do. So, we have a dilemma. We obviously love our kids. We don't want them to want for anything. And we need to make sure financially that they will be okay. But the government's saying no. You cannot leave them any money in their names, or else all the aid they're entitled to, all these wonderful government programs, they can't be part of. So what do? We set up something called a Special Needs Trust, or a Supplemental Needs Trust. And what that is, it's a separate entity, has its own tax identification number. So now, instead of the money going to your child and your child's name and their social security number, all we're doing is redirecting that money to their trust and the trust tax ID number. And the purpose of this trust is not for food or basic medical or shelter, because the government's going to take care of that. The purpose of this trust is for anything that your child needs that's going to make their lives better. For example, if they want a computer, well, that's what the money in the trust is there for. If they're living in a facility and everybody's going to Disney, it costs money to do that. That's what the money is there for. If there are medical expenses above and beyond what the government's going to pay for, because remember, the government is just going to pay for the bare basics. If down the road your child wants elective eye surgery and it costs $15,000, $25,000, $35,000, Medicaid's not picking that up. That's what the money is there for. The money is there for anything that your trustee feels that your child needs that's going to enhance the quality of their life. And by the way, a trustee can be anybody you name. It could be a brother, a cousin, a sister. Quite frankly, for most of us, at the end of the day, it's probably going to be one of our typical kids. Now the question is, well, how do we fund this trust? How do you put money into the trust? Well, there's lots of ways of doing it. You can fund it by opening up a savings account in the trust name and trust number. You could buy mutual funds in the trust. You can will money to the trust. But in my opinion, the best way to fund the trust, the most cost-efficient way, the most cost-effective way, is simply through a life insurance policy, and specifically through a policy designed for this called the Second to Die life insurance policy. A Second to Die life insurance policy is a policy on two lives, husband and wife, and when the second person passes, that's when the death benefit is paid out. Since two people have to pass for you to collect, the premium or the cost is significantly less than a regular insurance policy. And what that means to families like ours is we can get a lot more benefit at a lot lower cost. Like I had said before, as long as I'm alive, I can take care of my boys. As long as my wife is alive, she can take care of the boys. When the two of us are gone, that's when the money absolutely has to be there. And with that Second to Die insurance policy, the exact moment when the money has to be there is when it's there, guaranteed. For those who are single, there are wonderful policies for you as well, where the death benefits are permanent and the premiums are pretty inexpensive. This type of basic plan allows me as a parent to sleep at night, knowing no matter what happens in my life, financially, my kids will be okay. Whether I'm successful or I'm not, whether I live a long life or I don't. When the time comes that Jane and I are no longer around, our kids will be okay financially because we've taken these basic 4 steps. 1, we've gotten all the money out of the kids' names. 2, our wills were done by somebody who's an expert in that field. 3, trusts were established. And finally, we made sure to fund those trusts. So with that, I'm going to have Andy get into detail on the legal aspect of things. And then what we're going to do is open up the floor to any questions that you may have. I'm going to go around and hand out some of the, a lot of people were here when we first started, the sign-in sheets. And we understand that everybody's situation is different, everybody's needs are different, but if you fill out the sheet and give it back to us at the end, this way we can touch base with you on an individual basis. So, Andy?
Good evening, folks. I apologize in advance because I'm a lot more long-winded than Mitchell. My name is Andrew Cohen. I'm an attorney. And my role here is really twofold. It's to educate, but it's also to motivate. And the educational component's obvious. I'm here to give you the basic building blocks of information that you require so when you're building your family life plan, you know what you're looking to accomplish. It's the motivational part that's a little bit more difficult because everyone in this room is going to live 150 years. You have to. You have a child or family member who needs you to. But the reality is we're not around that kind of time, and the kind of planning that Mitchell and I are talking about today really needs to be done today. Don't worry about 30 or 40 years from now. It's cliche, but plan for the worst, hope and pray for the best, and you can always adjust things going forward. The person who might be the right guardian for your minor child today may not be around in 5 years, or be the right person in 10 years. You can always adjust and modify your plan going forward. So with that, we'll talk a little bit about estate planning. And when we talk about estate planning, really, we're talking about two core tools, wills and trusts. And everybody here knows what a will is, right? It's a legal document that once signed off on provides a roadmap for how you want your assets distributed when you meet your demise. And most people, if they have a will at all, sign that first will when they had their first child. They were concerned about, well, if something happened to me, if something happened to my partner, who would be responsible for that young child's needs? Does anybody know what happens if you pass on and you don't have a will in place? Anybody want to take a guess? The state writes your will for you, that's correct. It's not that the state gets your assets, that's a fallacy. But under your state-written will, your spouse gets a percentage of your individually held assets, your child or children get a percentage, or if you're a single parent, your child or children get everything. And as we've learned from Mitchell, a child with a disability receiving any kind of direct inheritance is not a good thing. In fact, it's likely to disqualify them from important government benefits that I'll get into in just a few moments. Now, a trust is a little less familiar to people than a will, but like a will, a trust is a legal document. And once signed off on, a trust actually creates an entity, not unlike a partnership or corporation. It often gets its own separate tax identification number. And there are three basic players to a trust. There's the grantor or settler, the one who creates it. There's the trustee, the person or persons assigned to manage the trust. And then there's the beneficiary, the person for whom you are creating the trust for, typically your child. And here in New York, you can create a trust one of two ways. You can create what's called a testamentary trust or an inter vivos trust. And a testamentary trust, as the name kind of implies, is a trust that's simply built inside your last will and testament. It's this safety net language that remains dormant and inactive until such time as you're no longer around. And the nice thing about having a dormant or inactive trust that's built inside your will is there's no administration. You have no tax filings. You have no bank statements. There's nothing to do other than to continue to live your life. And when you're no longer around, that trust springs into action and becomes relevant. Now, by contrast to a dormant or inactive trust, some people prefer to have an active trust, a living trust, one that's created now and funded now with $50 or $50 million or any amount in between. And once that trust is created, it gets its own tax ID number, it's set up at a local bank or financial institution, and not only does your will now pour over into this active trust, but insurance and retirement accounts are also linked up as well. And the benefit of having an active trust is if other family members or friends are going to look to gift or will money to your child with a disability sooner than later, this account is open and active and can receive these gifts or bequests from someone's will from most sources. Now here in New York, whether you do a testamentary dormant trust or an active trust, we do trusts for all different kinds of reasons. We do it for estate tax planning for our very wealthy clients. We do it for long-term care planning for our seniors to have them pick up the cost of their long-term care needs. But the kind of trust that most of the people in this room are or should be concerned about is what Mitchell described before, a supplemental needs trust or special needs trust. And this is a specially designed trust fund that allows an individual with a disability, as the beneficiary of the trust, to receive all the money, assets, wealth that you can provide, but without disqualifying them from public benefits. The government says you can only have a minimal amount of money and assets in your name to qualify for Medicaid and other means-based programs. The purpose behind this trust is to say, great, let the government cover what it's going to cover. Food, shelter, basic medical, OPWDD programs and services. Total benefits from the government to the tune of millions of dollars. The money that goes into the trust is to supplement what the government provides, to pay for the extra things that the state does not cover. Things like clothing, furniture, electronics, entertainment, vacations. It's anything and everything that will enhance the quality of your family member's life, but without disqualifying them from benefits. I think the best way to kind of illustrate how this planning works, how these trusts work, is to give you an example. And in my example, we talk about three families. The first of the families, family A, says we're going to work hard, we're going to save hard, and at the end of the day, when mom and dad are no longer around, whether they have wills and trust in place or not, Their children are going to get all their assets. Their typical child gets 50%, their special child gets 50%. Well, of course, that special child in receiving half of mom and dad's wealth loses out on benefits. So that's not a very good plan, not a good path to go down. So we turn to the second family in our example, family B, who says, I know we need to pauperize our special child. We got to get all the money out of his or her name, make sure they always remain eligible for benefits. And mom and dad and family B, they leave all their assets to each other under some simple wills. And then upon the passing of that second parent, their moment of greatest fear, their biggest concern, they disinherit that special child. They leave them nothing, saying they'll always qualify for benefits. Why don't we just leave it all to the typical child? They'll always be there for their special sibling. They'll take good care of them. And some of you are smiling and shaking your head because you know that's not a good plan. There are too many things that could go wrong with that well-intended disinheritance. That typical child who you've left all the money to could get into a bad marriage and lose that money. They could come across bad financial times and say, I love my exceptional sibling, but I need the money myself. Or in the worst case scenario, you've left all this money and assets and wealth to that typical child with the best of intentions of taking care of their sibling. But that typical child passes away first. Now the money's going to their family, to their spouse, their children, and leaving that special sibling with nothing but government benefits, which is not your goal. Which of course leads us with the third family in my example, family C, who does their planning correctly. Like the first family, they're going to split their assets equally or relatively equally among their children. Like the second family, they're going to pauperize that special child, make sure he or she is always financially eligible for their benefits. And they set up their estate plan with some heavy-duty wills, mom and dad still leaving everything to each other. But upon the passing of the second parent, typical child gets their share, maybe in a standard trust, until they're a little older, a little bit more mature. But for that special child, rather than leaving them the money outright or in a standard trust, both of which would jeopardize their right to benefits, they set up that supplemental needs trust. And now mom and dad's objectives for the future have been met. That special child gets all the money that they want. That trust is going to be managed by the people in their life that they choose, brother, sister, cousin, uncle. And most importantly, that child with a disability gets the best of all worlds. They get all the government benefits here, all the money and assets that mom and dad can leave there. It's the best of both worlds. Everybody with me so far? We'll get to questions in a moment, I promise. So inevitably, you're going to go home and you're going to Google Supplemental Needs Trust, do a little research. And in your research, you're actually going to find that there are different types of supplemental needs trust. The kind of trust that we just described with that third family, family C, where mom and dad set up their plan, and they and other family members are the ones to provide the funding. That is known as a third-party supplemental needs trust. And that's the one that most families are interested in. It's the one most families need. The beauty of a third-party trust is while you set it up now, you don't need to fund it now. Remember we talked about maybe a dormant or inactive version of that. Whenever that trust does get funded, it gives your family member with a disability the best of everything. But very importantly, at the end of that individual's lifetime, when there's no longer a need for this trust any longer, whatever money and assets are left over in this trust pay to that disabled individual's own children, if they have children of their own, or if not, it'll pay to their siblings, extended family, charity. It's wherever you, the creators of this trust, decide the money and assets ultimately end up. The government has no right to this money. They have no say in what happens to it. So you, the creators of this trust, should never fear overfunding it. Whatever your child with a disability needs, they'll have. Whatever they don't need during their lifetime, other families are going to benefit from it. Now, in your research, I told you there's different kinds of supplemental needs trust. Besides the third party or private trust that we just described, there's another type of trust called a first party or payback trust, which few of you will ever need, but I think it's not a bad idea to at least know about it. A first party trust is only needed, it's only created if the disabled individual themselves have assets. A disabled individual, if the money starts with them, can't put their money and assets, their income, their resources, into a private third-party trust. They would require this different first-party or state payback trust, which I refer to as a use it or lose it proposition. use it during their lifetime, but because the money and assets started with that disabled individual, that they provided the funding for the trust, rather than paying out to other family members, the leftover portion pays back to the state. So some of you are saying, why in the world would you create a first-party trust, one where the state has their hands in the cookie jar? And I agree with you. You don't do it unless you have to. But sometimes you don't have a choice. Typical examples of money or assets starting or originating with the disabled individual and requiring a payback trust are a lawsuit settlement or an unanticipated inheritance. If your son or daughter has a car accident, they break their elbow and there's a lawsuit, and now they have $40,000 or $50,000 in settlement, well, that's their asset. They're going to lose their Medicaid, their SSI benefits, unless they spend it all the way down, or they can shift it into one of these special trusts, but it's the use it or lose it variety because the lawsuit was their funding. More common than a lawsuit is an unanticipated inheritance. Long-lost cousin Joe says, I got a niece, a nephew in Nassau County, and they have that autism thing, whatever that is. And cousin Joe says, you know what, I don't have children of my own. I'm going to do a nice thing. I'm going to write a will. I'm going to leave all my assets to that young man or young lady in Nassau County with autism. And cousin Joe passes away thinking he's done a wonderful thing, which he did. But the money and assets coming directly to that special child disqualify them from benefits. Again, they're going to have to spend it all the way down, or they can shift it into one of these special trusts, but it's the kind that pays back the state. The better course of action for cousin Joe or grandma or anybody who's looking to do something financially for your exceptional child is let them know you have the third-party variety, the private family trust. And if they want to give or will money to that trust, they can do so, and that way the state will never have a right of payback, a clawback at the end of the day. Everybody understand the difference between a third-party private trust, most people need, and a first-party state payback trust, only needed if the money starts with your child. One other little wrinkle, you may have heard or read about the ABLE Act, which was passed in Washington back in December of 2014. This is a financial account akin to a 529 education account. It's actually a 529A. And for the last year and a half, they've been taking around regulations. You cannot set up one of these accounts yet in New York. Once the regulations are ratified, you can set up an ABLE account. It is an account in your child's name and social security number. There are some tax benefits to contributing to this ABLE account. But before you jump all in, you need to know a little bit more information about it. With an ABLE account, the money and assets that are in there are much more restricted in the way it can be used as opposed to a supplemental needs trust. With an ABLE account, it's only the first $100,000 that is exempt for Medicaid purposes. With a supplemental needs trust, there is no cap. You can have as much money to fund for your special child. And very importantly, with this ABLE account, once it is ratified, it too is a use it or lose it proposition. The money and assets that are in that child's financial account at the end of their lifetime, the remaining portion still pays back to the state. So that third-party supplemental needs trust remains the gold standard of government planning, protecting your child going forward. 3 other quick topics I'm going to touch on, and then we're going to open up the floor to any questions you have. When we're talking about special needs planning, the emphasis really is on the government benefits. We keep referencing SSI and Medicaid. 3 minutes on these topics, it's important to understand them. When your family member with a disability reaches the age of 18, if they have a disability which prevents them from being able to engage in work-like activity, and they have less than just $2,000 in total assets in their name, they are entitled to SSI, Supplemental Security Income. That's a monthly stipend. Someone who's living at home, living in the community, can get up to about $800 a month. It's nice, it's not life-changing money, but with that SSI benefit, that individual automatically gets Medicaid, and Medicaid remains the most crucial and vital set of benefits for an individual with a disability. It covers, as I mentioned before, everything from prescription drugs, hospital, medical, when your family member is no longer covered under your own health insurance. It may cover some kind of residential setting in the future, and I'm not talking about a scary, old-school group home. I'm talking about a customized living environment that you create, that you set up the supports for, but funded by the state. And very importantly, if your child can go on to college or if they can go into the workforce, that's great. But if they're not able to do that easily, they will require OPWDD programs and services, the Office for Persons with Developmental Disabilities. They provide all kinds of services like life coaches and job coaches for high-functioning individuals, or day hacks and life skills programs for lower-functioning individuals. OPWDD is 100% funded through Medicaid. Medicaid, the total programs and services over your family member's lifetime, is without exaggeration worth millions of dollars to them. You can never, ever jeopardize their right to the Medicaid, which is why this trust planning is so important. Once you have your will and your supplemental needs trust set up the right way, your child's assets will always be protected in the future, but most importantly, their right to the Medicaid services are also forever protected. Now, if you apply for SSI prior to the age of 18, the government will look at your entire household resources and income, and you may have too much, you likely earn too much for your child to get SSI prior to 18. Once they turn 18, the month after their birthday, you can apply to Social Security, and that office will no longer consider what the parents earn. They'll no longer consider what the parents have in assessing that SSI benefit. Medicaid also has this deeming process where they look at the overall assets and income, but they also have a waiver program. If your child who's a minor has significant medical issues, Medicaid can provide waivered services, respite, rehab, pay for equipment, even while your child's a minor. Now with SSI, we talk about Medicaid. For some of you, your family member with a disability may get something a little different. SSDI, or Social Security. And that's based upon your work record. If you as parents become disabled, retire, or pass away, all that money that you contributed to Uncle FICO over the years out of your paycheck will benefit your child with a disability. Your adult disabled child can benefit a percentage of your Social Security. And with that SSDI comes Medicare, or you usually think of as seniors insurance. So, at this point, everybody's eyes start glazing over. What the heck is he talking about? It's your job as parents, it's your job as advocates for your family member to learn as much about the system as you can and make sure that your family member always remains financially eligible for everything they're entitled to. Most important is that Medicaid. Two other quick topics we're going to touch on. The next one talks about advanced directives and guardianship. When you sit down to do an estate plan with an attorney, you don't just do your wills and your private third-party supplemental needs trust. It's important for you as competent adult persons to have a set of advanced directives for yourself. Documents like a power of attorney, a healthcare proxy. These are documents that would appoint your spouse, a sibling, a friend, someone to act for you in the event that you are unable to act for yourself. An accident, a stroke, any kind of incapacitating event, these documents become crucial, appointing family members or friends to act for you. Now, for you as parents, you are the legal guardians of your minor children. You have the right to make all of their important decisions, right? Medical, educational, legal, and financial. Something happens to you, your will dictates who you would like to appoint as a guardian for that minor child if mom and dad are no longer around. What's very surprising to a lot of people is, while you're always a parent, you are not always a legal guardian. Once your child or family member reaches their 18th birthday, the law presumes that they are typical, able, and capable of making all their own life decisions. Well, for some, if not many in this room, when your family member reaches their 18th birthday, their cognitive challenges may prevent them from truly understanding and appreciating what it means to make life decisions. So what do? The law says they can at age 18, and you look at your child's testing and their IEP and you say, there's no way. Well, fortunately, there's a process called guardianship where you can go into court and become the legal guardian for your adult, developmentally disabled child. There's actually two types of guardianship here in New York. There's a simple, inexpensive process called the 17A guardianship, which is usually the focus of what we talk about for our population, for our families. If your child falls under the umbrella of having a mental retardation, developmental disability, or similar cognitive challenge, a simple petition to the surrogate judge in the county that you reside in, applying for guardianship, supported by some basic supporting documents, some affidavits, some waiver forms, a background check. But the key to the courthouse, the key to the kingdom, if you will, is that you provide the judge with medical certifications, either 2 medical doctors or 1 doctor and a licensed psychologist that can certify for the judge that your family member has deficits that prevent them from being independent and self-sufficient. And once the judge reviews that and is satisfied that there's a developmental disability, that they can't understand and appreciate their own life decisions, a brief hearing is held, and a result thereafter is a court order, a decree, that names you as parent or parents as legal guardians from age 18 and the rest of that individual's life. And even though you're going to be around forever, I understand that. Just in case, you typically appoint a standby guardian, maybe a second standby guardian. There should always be somebody under that court order that provides the authority to speak on behalf of your family member, to make sure they're living in a safe place, getting to the doctor regularly, spending their time productively. Without that court order, your 18-year-old with autism, your 19-year-old with Down syndrome, if they end up in an emergency room with a big gash on their head, and they say no, no, no to treatment to the doctors, guess what? Those doctors are not going to touch them. And they can't look to you as parents to override your child's decision. They're an adult. They're certainly not going to share HIPAA-privileged medical records, right? Once you have that guardianship order, you are free to speak to all doctors, social workers, educators, just like you did when your child was a minor. Now, you're thinking, my child's 12 or 13, do I need to do this now? The answer, of course, is no. You are parents, you are natural guardians. But as your child's approaching the age of 18, 17 and a quarter, 17 and a half, if they have a developmental disability, it's a simple, inexpensive process in the surrogate court. Again, it's called a 17A guardianship. The last topic that comes from me actually comes from me as a parent, not as an attorney. Mitchell mentioned his twin autistic boys at the beginning, correct? Mitchell lied to you. Mitchell's got 3 boys on the spectrum, not 2. Me, I'm the father of 3 daughters. The oldest of my 3 daughters, the young lady on the brochure, Jenna. Everybody look down and go, oh, she's so cute. Come on. Thank you. Jenna just turned 18 last month, and Jenna has permanent and chronic disabilities. So I sit in the same proverbial seats that you do. I have the same stressed out, anxiety-ridden life that you lead. And obviously in my life, we set up our estate plan. We have our wills. We have our third-party private supplemental needs trust for Jenna. Standard trust for the other 2 girls. And we've coordinated a nice financial plan, including the type of insurance that Mitchell talked about before, to ensure that Jenna always has enough funding in that trust. Now, because Jenna turned 18 in April, because Mitch's twins turned 18 in February, we've already completed that simple guardianship. We have the right to continue speaking on behalf of our children. But from a practical standpoint, from an emotional standpoint, if something happened to my wife and I last week or last month, which it didn't, my sister-in-law is appointed as guardian under that court order, and for my other 2 children under my will. She's trustee of their trust. But my sister-in-law doesn't live with us. She doesn't even live in the state. How in the world is she going to know what to do on day-to-day operations? Sure, she's got the legal and financial structure all set, but what about day-to-day? What we've done in our life, what we've always recommended for our special families, is that you put together something called a letter of intent, or family love letter. This is not a legally binding document. It's not created by anybody but you, because it's personal to your life. In my life, we have a loose leaf book, and in it we've broken it up into sections. There's a section on education with Jenna's IEP. There's a section on medical history with all the testing, treatment, diagnosis, therapies. There's a section on legal, a section on financial. Now, my daughter's come a long way in 18 years, but she's still not nearly as verbal as I'd like her to be. So we have in our book her likes, her dislikes, her routines. If she's having a meltdown, the instructions to my sister-in-law are, get out the iPad, hit the YouTube app. Jenna's going to scroll through her videos on that iPad. That's going to calm her down. You're smiling because it's the same thing in your house, I know. It's everything and anything that your go-to people need to know about day-to-day operations. I talked from the beginning a while back about motivation. The reality is, doing your estate planning, doing your guardianship, doing your financial planning, even doing this letter of intent, None of this stuff is going to make your life any easier day to day. We all go down a path that's very unique unless you're living this life. But once you put the legal and financial structure in place, it's a giant weight off your shoulders. You still have a ton of stuff to deal with OPWDD front door and Medicaid applications and IEPs, but at least get the financial and legal structure down. You don't have to think about it. Told you I was long-winded. With that, I'm going to invite Mitchell back up to the front. We'll open up the floor to any and all questions you have. Please keep the questions general for everybody.
By the way, did anybody not receive the brochure?
Sir, first question.
There for third-party supplemental trust.
Yes.
If you have third parties, meaning other individuals contributing,
Yes.
are there any benefits that they get, be it tax or akin to giving to a charity?
No. This is where the Medicaid, the welfare laws, and the tax laws kind of come to head. Most people are aware that each year a person can give $14,000 a year to as many individual people as they want, tax-free. And for certain trusts that you establish, you can still give that $14,000 and still qualify for that gift exclusion. With a supplemental needs trust, the contribution to that doesn't qualify for the gift exclusion. That being said, they can still make a generous tax-free gift. Rather than qualifying for the $14,000 annual exclusion, it would simply come off their lifetime exclusion. Each person gets $5.5 million of lifetime gifting during their lifetime, above and beyond that $14,000 annual. So my father-in-law, generous man, likes to take care of all his grandchildren, right? $14,000 to each of my 3 nephews. $14,000 to my 2 typical girls. He'll still give Jenna her $14,000, but he's going to put it in her trust, and rather than qualifying for that gift exclusion, he writes it off as $5.5 million lifetime exclusion. Now he can only give $5.4 million, 850, whatever thousand. Yes.
Yes.
Regarding second to die life insurance policies, if we already each have a life insurance policy, is there any difference between naming special needs trust as a beneficiary?
What you're going to do is this. It's actually apples and oranges. You need to have life insurance to protect each other. And then what you're going to do is change the contingent beneficiary on those policies. You're still going to have my spouse as the primary beneficiary, but now it's going to be typical child A, typical child B, trust C on the as the contingent beneficiaries. But you still need that to protect each other. This policy is specific to go directly to the trust. I'll give you an example. Again, as long as I'm alive, as long as my wife's alive, we're going to take care of the kids. But I need to know this significant money going to the boys after we're gone. Not only for the special needs ones, but for my oldest son, Stephen. Because chances are he's the one who's going to be in charge down the road. And as long as there's enough liquidity, and that second to die policy is going to give that to us, the boys will always be able to live in the house. That's my goal. I want the boys to always live at home. They're comfortable there, they're happy there, they would never be able to afford to live there. But as long as there's enough money in the trust, Stephen will be able to hire somebody to live in the house with him, pay the taxes, pay the cable bill, pay everything. And like Andy described before, because this is a family trust, it's a private trust, Stephen will use whatever money is necessary for his brothers, and at the end of the day, when the boys pass, it all comes back to Stephen. So the idea is we want to make sure there's as much money there as possible, and you're still going to change those beneficiaries, but the contingent beneficiaries, because you're still going to need the life insurance to protect each other. But people generally do a specific policy for the child who really needs it. And I always tell people, you do what's affordable, you do what's comfortable. You know, right now we have $2 million of that second to die, and that lets me be comfortable knowing that the boys will always be financially protected. Any questions? Yes, sir.
How do you give a situation where parents live a long time, not working for at some point, so you don't get the benefit of the second to die policies for a significant time? The child's only going to be in his 40s or 50s, or the parent becomes disabled, and how do you deal with those situations?
Well, for most people, the way they look at it, as long as they're alive as parents, they're going to take financial care. The purpose of the insurance is really to help fund that trust going forward. Right now, with OPWDD self-direction, which is the big trend, if your child is somewhat independent, and the goal is to make them as independent as possible, through OPWDD, they're going to allocate a budget based upon their needs, and that'll cover a lot of their residential and transportation and day needs. It doesn't necessarily cover the good things, the extras that we're talking about. That's really what the trust and the financial planning is about. A lot of their basic needs are going to be met now and for the next 20, 30 years. But we don't have a crystal ball. We don't know what tomorrow holds. We do know that we need to protect those benefits no matter what. As a bonus, we can still put it into this supplemental need trust to make sure the money's going to be there.
The government benefits over the course of our kids' lifetime is really worth millions of dollars. We can never jeopardize that. But I don't want to rely completely on the government. I want to have money in the trust that when I'm gone, for the good things in life. As far as the insurance policy, I could also access the cash value from that policy. But the idea is we're creating the best of both worlds. The government money over here, which we cannot jeopardize, but the money here for all the good things. Anything and everything to make them happy. Yes, sir.
With regard to wills, if typically, let's say, a grandparent or a great-grandparent were to give to a grandchild, I think there are tax implications in terms of skipping generations.
Generation skipping, that's a pretty large gift they're giving.
So if you give it, if you have it done to a trust, do you know if that changes the...
It doesn't necessarily change how the tax implications are, because it's taxed at the decedent's level. But you're talking about a really substantial gift to really affect generation skipping taxes. You're talking 7 figures, okay? So if grandparents want to do that, they really need to sit down and do some really sophisticated planning. There may be some other things that they can do which can really benefit that child rather than just, we'll skip a generation and we'll have the money go into that child.
You can speak to us afterwards about that, but that'll be that. Yes.
Hi, in regards to the SSI for minors, so if you have a minor that is disabled and you're applying for benefits for them before they introduce you, you mentioned the earning capacity. They base that off the household income. So what are they looking for in terms of how much the parents are making?
I believe it's just around 26,000, 27,000 in total income for that. Below that, then there may be some SSI eligibility.
So if they do qualify for the benefits for the minor, once the child turns 18, and let's say a parent dies, and they put money into the system, will the benefits change as they kind of...
Yes. Not uncommon for a young man or young lady who's receiving roughly $800 a month from SSI at 18, 19, 20, and suddenly the parent passes away. Well, instead of SSI, they would get SSD, the survivorship benefit, which is typically higher than the SSI benefit. Instead of $800 a month, maybe they're getting $1,400 or $1,500 a month. So there's things that still need to be tweaked with that, but they can get more based upon that parent work record.
Sorry to interrupt. There's a meeting permission downstairs as soon as the session is over. Downstairs. Is
the second die policy, are you talking about the term?
Never a term. It has to be a permanent policy. It's actually a blended whole life second to die policy. A whole life policy, for those who don't know, is a pretty expensive policy, but it's permanent, it's guaranteed, and that's great, but it's really not what we're looking for. We as special needs parents are looking for permanent insurance as inexpensive as possible. So again, the whole life policy is great, not appropriate for this. Term makes no sense because nobody ever collects on a term. 99% of people don't collect on a term policy. So what this policy is, it's a combination of whole and term mixed together. So instead of costing this, it costs half of that. But we're doing it on 2 lives instead of 1. So instead of costing this, it costs half of that. So it's about a quarter of the price of what a regular whole life policy would be. And again, the more you can do, the better. But it's the least expensive way of guaranteeing from day one that the kids will be protected. So I know no matter what happens, Jane and I died, no matter what happens, $2 million goes to their trust.
And just to clarify, the term will pay out if you pass, but it has to be in that term. Mitch's point is most people outlive the term. That's why all the insurance companies have the biggest buildings in Manhattan.
I'm just wondering, if the child is high functioning, they be the only trustee of their supplemental needs trust, or they always need somebody to be in charge?
Unfortunately, they can't have that kind of control, and the typical arc here is that the trustee can't give them cash either. Instead of calling them a high functioning, I typically call them gray area kids because they're not typical, but they're not like my daughter. They kind of fall in that area where maybe they can work a little, maybe they can't. The goal for a gray area kid is, A, do you do guardianship? The answer is it depends, child to child. In terms of government benefits, if they're able and capable of working, that's great. Let them do so. The more they're able to earn, the less SSI benefit they'll get. But as long as they get $1 of SSI, they still keep their Medicaid. And in a situation where a child's really high functioning or really gray area, even if they're earning too much to get SSI, there's something called the Medicaid buy-in program where they can actually buy Medicaid benefits. They can earn up to like $50,000 a year and still get Medicaid supported services. So you can Google and research that one as well, Medicaid buy-in.
I think what we're going to do is take a couple more questions because I think there's supposed to be another session. 2 more questions. Yes?
The Supplemental Special Needs Trust, you said that if the special, beneficiary passes, then it transfers to a sibling.
The third-party version, that's correct.
Right.
Or
so
whoever.
That has to be declared in the trust.
Correct.
The beneficiary on.
Correct. You're going to write directly into your trust. If that disabled child passes, the money and assets go to their own children. If not, it's going to go to their siblings, or if there are no living siblings, it goes to XYZ.
What we do is, again, we have those sheets that we passed out. If you are interested in talking about your family, fill it out, give it to me, I'll contact you. We'll set up a time to get together at Andy's office. There's no charge, there's no obligation. We'll just talk about your family, the things that need to be done. And I'll just tell you as a parent, once this is all done, once you have a legal plan, once you have a financial plan tied into it, I swear it's just a weight off your shoulders, your kids are going to be protected that way. So we thank you very much, and if you have those sheets, that'd be great.